This TV show is made available to provide general information and a general overview of legal principles. Viewers should not rely on the information provided without consulting an attorney who is licensed to provide legal advice. Topics and ideas shared on this show are not to be used as a substitute for legal advice from a licensed attorney in your state.
Hi, and welcome to Under Oath with Michelle Bell. I'm your host, Michelle Bell. I am a licensed attorney, and this is my show where I bring on other attorneys, and we give you, the public, legal information without that consultation fee. So I like to start the show off with a segment I call Jury Duty. It's similar to trivia, where I give you a question, and the first person to submit their answer on our website will receive a gift and their name on the website, which is www.mbunderoath.com. So you ready for the question? Here we go. Which major American airline is named after a Greek letter? Okay, that one is easy, so send it in your answer. Also, check us on our different social media. So we have the website, which is www.mbunderoath.com. That's where you can see all our shows. We're also on LinkedIn, Twitter, YouTube. Just find us on there and subscribe, definitely, so you can get all the legal tips and notifications of the shows, okay? So hang tight. We're going to have a special guest on, and they're going to talk about employment law. We'll be right back. Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. Surprise again, I am the special guest this time. I'm doing part 2 of employment law. So part 1 was from the employee's perspective once you're terminated. And part 2, which is this video, it's going to be from the employer's perspective, okay? Now, if you want to review part 1, you can go to the website, which is www.mbunderoath.com, and you will see part 1 as well as the other shows that have already aired, okay? I'm going to take it from the perspective of the employer, and one of the things that can either make or break a case when the employer has terminated its employee is the documents or the lack thereof, or you may have the documents and it doesn't contain enough information. Documents, documents, documents. That should be like ringing in your head at all times. You need to have documentation of everything that's occurred that's pertinent. So for example, if an employee, did not do something correctly or was put on probation for a specific reason and you spoke to them orally, that's fine. However, you need to also have like an internal memo of what happened, because again, people don't remember everything when something happens. So say in 3 months' time, the employee does something else again, you're not gonna remember all the details of what happened the first time 3 months ago. So if you have it documented, you can always refer back to it. It's like you may not even remember what you ate last week, but now you want to remember all the details of something that occurred 3 months ago. And especially if you're a supervisor and you are over, 30, 50, 80 people, it's kind of hard to keep track of all the details of what happens. So employers, teach your employees, especially people in management, document everything. even if it's just like a verbal warning or whatever, it's a internal memo that you can do. If you want to demote a person or suspend them, probation, if you keep documents of what occurred, it makes it a little bit easier. And also give a copy to the employee so that they have it for their records, you have it in your records, and HR may have it as well. But that is key. So not only have the documents, but what the documents say. The document, especially if you're a management, so we're going to take it from the management perspective. If you are a supervisor or manager and you're writing up an employee, I can't tell you how many times I've received documents where basic things are missing. Have it on company's letterhead. Have your full name on there. Have, your title. Sign it. Have the date on there and have the employee's name on there. I've been in situations where my client was actually the employer, and they had all these internal memos about, the employee they terminated, and that was the subject matter of the case, and we couldn't tell. There wasn't any dates, there weren't any signatures. The employee's nickname was on there, not the employee's full name. The manager or supervisor never put their name on it, so and it's on regular paper. It's hard to show what you're talking about, who you're talking about, when this was dated. It's a lot things come into question when you don't include that basic information. Create a template. Letterhead, date, employer's information, the manager's signature block at the end, with their name, their signature, and then that way all you have to do is just plug in the employee's name or whatever, the details of what the situation was that occurred, and then you have it. And it makes it a lot easier. I understand if you're managing a larger number of people, it can get real hectic because as well as your regular duties, you also have to write and keep track of everything that these employees are doing. I understand that, but put in the time now, because if something happens later on, you can't go back and create those documents. You'll already have it, and it will save so much time, and it will assist and help. And not to mention, as a manager, it will make you look great to your employer if they come to you and say, hey, remember, Susie that we terminated last week, she's now claiming discrimination and all these other things. You can say, well, I follow protocol, and this is how I follow protocol. You have all your documents, everything in a row. They give all the details, the information. They have the signatures. They have her signatures. You have that you gave her copies. You have all of that, and you can just pass it over to your employer. You look awesome. And it makes it a lot easier. So, yes, please have that pertinent information in your documents. Another thing is, when you hired that employee that you are now either considered terminating or you've already terminated, when you gave them the employee manual or an employee contract in the beginning and all these other, clauses and agreements and stuff for them to sign, you have to also follow what you put in those documents. So yes, the employee has to follow it, but you also have to follow it too as an employer. If you do not, you are opening yourself up to a lawsuit. You can't, for example, you can't have in there, and I think we discussed this in the last video, a non-disparagement, clause. You can't have that in there and then you're trashing the employee on a, office-wide email. Such and such was fired because they, lied every time they were late. They said their grandmother died like 5 times in 1 month. This person is just lazy. This person is just, all these negative things. If you have in your policy that they can't do that and you can't do that, then you can't do that because it's written in your own policies. If you say that you need to give this person a 30-day notice before you terminate them, it's in your policy. Give them the 30-day notice. I mean, that's just what it is. If you were that specific in the terms that you put in these agreements and these policies and these manuals, then that's what you have to abide by. You can't just be, oh, okay, well, this person, I've had enough of it. That's it, done, gone. But in there it says you were supposed to give them 30-day notice before you terminated them. You can't just do, that's it, gone. You got to give them the 30 days. You know, so you have to follow your own policies and procedures the same way you want your employee to. If not, you're opening yourself up for a liability. You also want to keep documents just in case you are hit with a discrimination clause. I'm sorry, a discrimination claim. You know, if this employee is claiming that you discriminated against them because of their disability or their gender or their age, you know, or anything like that, your documentation can show like, well, no, when this person said that they were sick or they had a disability where they can't lift, you know, 10 pounds of paper or 5 pounds of paper, they have to be limited in what they can do, and you have documentation of that, and you also show that you've limited their responsibility to suit, you know, what they can do based on, you know, the documentation or the doctor's notes or anything that they submitted. You want to have a record of that as well. So the same way you, the employee covers themselves, the same way that you cover yourself as well. Anything that's occurring, you need to have a copy of it. Even if you do not think that it is a make or break or it's important enough, you keep it because you never know what's going to happen. Plus, it can help prove that you did not terminate this person based on, you know, discrimination. That really you terminated this person, you know, for whatever reason. And again, like I stated in part 1, I'm licensed in DC as well as the federal courts in Maryland. So DC is an at-will jurisdiction. Employers don't have to give, you know, a reason why they terminate. They can't, you know, but they don't have to. There are exceptions to that. But again, if you're watching this video and you are in a different state, please contact an attorney who practices employment law in your state, and they will let you know. Now, if you don't know who to call in your state, you can contact the show and, you know, send an email, go to the website, send an email, and, you know, we'll try to reach out to attorneys that we know in your state and then pass your information on. Now, we don't endorse those attorneys. We're just giving you someone that you can contact. But definitely speak to someone that's licensed in your state and practices employment law. So we're actually going to take a break right now, and when we come back, we're going to go into office hours and some more about, you know, from the employer's perspective on employment law. We'll be right back.
Okay, so what would you bring to my company?
What do you need?
I need problem-solving skills.
I got through high school without a car, a phone, or a computer.
No college degree, though.
Not yet, but life's taught me a lot, and I'm ready for more.
Well, you're not the typical kind of candidate that I hire. But you are exactly what I'm looking for.
Your company could be missing out on the candidates it needs most. Learn how to find a great pool of untapped talent at gradsoflife.org.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell, and I'm also your special guest today. So we are continuing part 2 of employment law, but from the employer's perspective. So right now, we're gonna go into our next segment, which is office hours. I did have some questions sent to me. They were not audio or video this time. So I'm just gonna get right into it. All right. First question was, I never had an employee manual, so I can't get sued for a breach of contract, right? So I'm gonna say that this came from an employer. And that is not necessarily true. So contracts are, you know, you have the one that's written and everybody signs it and reads it, but you also have what's called the implied contract. Now that is an agreement created by your actions, by the parties involved, not necessarily something that's written. So for example, if, you know, we don't have anything in writing, but you as an employee come to work and me as the employer, I pay you every 2 weeks and you did this type of work, and we've been doing that for like the past 6 months, 8 months, or a year, we have an implied contract. So even though we don't have anything written, your action was you came to work every day, you did these particular jobs, I paid you every 2 weeks. That's an implied contract. So just because you don't have an employee manual or any documents saying that this is what I can do, what I can't do, and because you don't have one, they can't get you on breach of contract, that's not the best thing, and that's not true. But you need to have something that lets your employees know what they can and can't do, okay? All right, next question. If the terminated employee does not return the company's laptop, how do I get it back? All right, well, first I would say consult an attorney that's licensed in your area or in your state and let them know that you want it back. Now, you also, as an employer, have to weigh it. So is it worth that laptop? Is it worth going after the employee, hiring an attorney to go after that employee to get the laptop back versus the amount of money you have to pay this attorney to get the laptop back from that employee? So look at it and see, is it more beneficial? If you just, they can have the laptop and you just write off, the cost of it, or if you want to prove a point and say, no, this laptop was worth a lot of money, it has this, it has that. No, we're going to get our attorneys to go after that employee and get that laptop back. You have to make those decisions and weigh it. Sometimes it's easier and better to cut your losses. Sometimes you do have to prove a point as an employer. Like, no, you can't just take advantage of me in that way. But yeah, I believe those were the questions that were sent to me. So hopefully you got your answers to that. And it's great because those actually segue into what we were talking about before. And we'll just go back to it where I had discussed that, your policies and procedures as an employer, you have to follow what you wrote. It's plain and simple. The next thing is if you are making a decision that, you're going to give a warning to the employee or they are just not, performing the way that you want them to perform, it is general practice that you do document that and give them a copy. And, allow them enough time to try to rectify that or fix it. You don't have to, but you can. But document it, and if you decide like, oh, I'm going to put them on probation for about 30 days, 60 days, whatever the case may be, write that down. When you have that discussion, write down what it is that you're discussing with them. Like, hey, I'm going to put you on probation, but this is what you have to do to get off of probation. We'll circle back around and, see if things have improved. The more communication you have with them, the better it is, and make sure you write down all of this information because you never know. Everything may be good and fine and dandy now, but 6 months, 8 months, 4 weeks, things can change. And this way you have a backup of it. But I also want you to be mindful of, when you're writing these documents and when you are putting this employee on probation or suspension or demotion, things like that, pay attention to, things that may appear to be, falling within the discrimination categories. So are you treating this person differently from those that are similarly situated to this employee? Is there a difference when it comes to, because I think a lot of people do the gender, the age, the disability discrimination claims. So look at it. Is the supervisor, the manager, or whoever is writing these documents, as the employer, you should be aware of these type of things that are occurring in your business. Pay attention to, okay, is this really happening? Look at what's being said, look at the reports, look at the documents, see what's going on, because again, ultimately, the person who owns the business is the person that is responsible. So you need to check on your managers as well and make sure that they're not, discriminating against employees. Again, check everything. Have have open communication with your people in management. have them report to you, like, okay, this is what's happening. Meet with them if you can once a month and just see what is going on in their department, see what is going on in that area. Ask them, let me see the reports, the documents, like what happened in this situation? What did you do to rectify it? Things like that, because again, nobody's perfect. Managers may have the experience in there, but again, no one's perfect. But you may have a solution that will help, because ultimately you don't really want unhappy people working there. You really don't. You're not going to always have happy people. This person may not like that person. I mean, that's just part of human nature. So some things you have to look at it for what it is. This personality just does not mix with this personality. But if these are really, really big issues or really core issues, see if this is something that can be worked out. But the only way that you're going to know if you are the owner of the business is if you have that communication and you see those documents, because you're not there when these situations occur between the manager, the employee, or even two employees that are on the same level. But definitely look, for signs like maybe there is discrimination there, because again, you fire an employee may have, some type of evidence or claim that falls in there, and you want to be able to, argue that no, it wasn't, and truthfully argue it. Another thing to look at, I'm looking at my notes right now. Try to be truthful with the employee. I understand that there are things that you can do. There are some things that you can't share with every employee, but be truthful with them. There's no reason to, hide the ball and create an atmosphere of failure. That's where you start to have the problems. If you know that this person has a problem, like say, for example, if this is a secretary, and one of the things is they're not the most proficient in Word, and you have like access to online training, be truthful with them and say, hey, there are some things that I'm noticing that maybe you don't get the documents out on time, or they're not as, they don't look as great as they can, maybe you need to spell check a little bit more. Like, go ahead and let them know that, hey, here is some resources that can help you. Here's a video, things like that. Like, be honest with them. Don't set them up for failure, where it's just like, well, I know this person can't do it, so I'm just going to give them this project to do, and their deadline is in 2 hours. And this person is not going to get it in 2 hours no matter what. I mean, just be honest with them. That can help alleviate a lot of things as well when you're deciding what's going on, because you do want to be fair if you are going to terminate this person. Definitely contact an attorney that's licensed in your state. If you're in DC, you can contact me. My website, my law firm website is www.mcblaw, P as in Paul, LLC.com. You can call the office, which is 240-230-3633. And honestly, if you're outside of this area, you can contact the show, and we'll try to, forward your information to attorneys in your state. You can send it to the website, which is www.mbunderoath.com. And we're going to take a break right now. We're going to come back with Plead the Fifth and Cheat Sheet. We'll be back in a few. Don't go anywhere.
It's a big responsibility.
Oh, it's huge. I know, it's huge.
And the salary.
Oh my God, yes.
Right?
I mean, like, I was about to move in with my parents, and right before, so this saved me.
I really believe in you,
Thank you. It's nice to hear that from someone.
These are cool. Did you, what did you?
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. Now we're going to go into my favorite segment, which is Plead the Fifth, and then we'll go into Cheat Sheet. Now, again, since I am the guest, these questions were actually sent in. So I haven't looked at them. You're going to get my complete original reaction. All right, first question. What is your favorite holiday? it's a toss-up between Thanksgiving and Christmas. Thanksgiving because the food, I mean family too, but the food really. And Christmas, especially when it snows, it's just beautiful and awesome and the love you feel. If you could travel anywhere, where would you go? Oh my gosh, Australia. Have you ever received a speeding ticket? Okay, so I'm gonna plead the fifth on that one. Do you prefer shopping online or in the store? Ooh, online. And what was your first car? So I'm a big Nissan Altima person. That was my first car. So these were cool. These were great. Now we're gonna go into cheat sheet. And that's where I'm gonna give you legal tips in layman's terms. So for you employers out there, here are my tips. First one, document as much as possible. This will be your lifeboat if something happens. So make sure you have the pertinent information in it. Because again, everyone's memories are not the same, you know, months, years down the line. The next one is, if you can, please have an employee manual. That way, your employees and your managers, everybody involved, they know what they can and cannot do. Okay? The next one is have frequent communication with your managers if you have managers and supervisors. If you're small and all you have is employees, have frequent and somewhat open communication with them, because a lot of things can be resolved without it even having to get to a court. And that's really what you want, and it's cheaper that way, seriously. So those are my tips. Now, if you have more questions, employment law, reach out to other attorneys that are licensed in your state, or you can contact me if you're in the DC area. And my information is www.mcblawp.com. My office number is 240-230-3633. If you are not in DC, you can, and you don't know attorneys in your area, you can send the show your question or your information and send it to the website, www.mboth.com, and we'll try to get your information out to attorneys out there in your state, okay? Now, definitely, please, 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 check us out on social media. We're on LinkedIn, we're on Twitter, we're on YouTube. The website has all of the old shows on there, and this show. So send in your jury duty answer, questions you want answered from office hours, and your plead the fifth questions that you want me to ask. Again, the website is www.mboth.com. Subscribe so you can get all this great legal tips and information and know when the stuff is posted. Okay? So I look forward to seeing you in the next show. Thank you.